A very good morning. I am really thankful to all of you for sparing your valuable time on this Saturday morning. Sunday morning, this Sunday morning. This is otherwise a holiday and you have spared time for me. I am really overwhelmed with your presence. I am especially thankful to Dr. Srinivas Kakkilaya, who gave me this opportunity to add my thoughts in Comrade B.V. Kakkilaya inspired Oration 2025. The subject, balancing constitutional and social morality in India, in Indian context. In fact, this was suggested to me without the word balancing by Dr. Kakkilaya. But a judge sitting in me that thought that let balancing be added to it. I was under this impression that because before Dr. Kakkilaya, I received a call from Mr. Muralidhar, a senior advocate. He conveyed me that some Oration lecture series is there, so you please come there. I was absolutely under this impression that it would be a conference of lawyers, it would be a conference of some people coming from legal arena. But when I read about the great freedom fighter, a champion of equality, justice, dignity of human beings, Comrade B.V. Kakkilaya, I thought this balancing is absolutely unwarranted here. It is constitutional morality and social morality in Indian context. When I came here and I met the people here. I was not knowing much about the Mangaluru. This is Dakshin Kannada, a multilingual area where Kannada, Malayalam, Konkani, all are spoken equally and mostly. I am really sorry. I have not learnt Kannada or any of the language locally spoken here. So please permit me to address in English. Otherwise I would have conveyed my thoughts in the local dialect. Friends, the subject balancing constitutional morality and social morality in Indian context. You must have thought that how this subject is relevant now after 75 years of getting our constitution enforced. This is an old story. The constitution was adopted, enacted and given ourselves much back in the year 1949 and enforced in 1950. Now what remains? We have a democracy from last 75 years. We have sometimes called the largest democracy. So what is the relevance of this subject? How we are now concerned with this constitutional morality, because constitution with its all values we have adopted and much back on 26th of November 1949. that has been enforced on 26th of January 1950. But holding elections in 5 years, is that the only constitutional democracy? Whether certain people sitting in assemblies or in parliament deciding the fate of crores of peoples, is that only democracy? Or democracy is something different? Because I am using the term democracy because it is the system that decides our constitutional morality as well as social morality. In fact, sometimes it appears that we are having elected feudals. Once in 5 years, we elect our bosses and then forget. After 5 years, again the festival of elections come. We again participate in that with all ills which are existing in our society. Casteism prevails. Communalism is the best weapon nowadays. Regionalism, money power, muscle power, what not else. Every ill is existing. So as a matter of fact, though we adopted constitution, though we desired, we dreamt for having a wonderful rule, a people's rule, but we are having elected monopolies and elected feudals. We are governed by them. This was not the intention of our framers of our constitution. They wanted something different. When we talk about morality, constitutional morality, social morality, then we are required to understand all these three terms within the framework of our values. And what are those values? What is morality? What is constitutional morality? What is social morality? When I was in my primary school, I had a subject, moral science. I had certain stories, very good stories, that a boy who was going, a shepherd boy, every day he was shouting, "Bhediya aaya, bhediya aaya." So this was the moral, was you don't speak lie. Other story, one young boy, he saw a hole in a dam, he put his finger there and kept the water intact. So let sacrifice for society. So what in general I understand is that the moral means feel good. Feel good doesn't mean that's a feel good, the slogan given in 2004. I mean feel good, happiness. Happiness for everybody. Happiness from grassroots. So when I think about the constitutional morality, social morality, I think there is no place for ills. when we are talking about our constitutional morality, I remember our national movement, our freedom struggle. I am coming from a part where that was not within the limits of the British India. That was a princely state. But there too, a national movement was there. There too, people were fighting against feudals as well as imperialistic powers. To my understanding, that our freedom movement, our national movement, that had two phases. One, let the imperialist powers go away. No more British Empire. But the major thing was, please go away all our social ills. This entire country is facing so many social ills. This is suffering from communalism. This is suffering from casteism. This is suffering from untouchability. This is suffering from discrimination on the ground of gender, on the ground of economic status. So we wanted to remove all these social ills, and therefore our second part of national movement, that is the making of India. That making of India is not only industrialization, not only developed agriculture, not only developed judicial system, but a complete fair system where the equality prevails, where justice prevails, where fraternity prevails. The biggest leader of Indian national movement, Mahatma Gandhi, he was not only against the Britishers. He was fighting against untouchability. He was fighting against communalism. He was fighting against gender discrimination. Similarly, all other leaders, may those be coming from reformist thinking or the revolutionary thinking, they were fighting for vanishing, for removing all those social ills. On 15th of August 1947, we call it Independence Day. This was an outcome of the struggle of Indian people, Indian masses. And also an enactment in the name of Indian Independence Act 1947. Indian Independence Act 1947, the section 1 of the Indian Independence Act, and its introduction. What it mentions, there shall be two dominions in the name of India and Pakistan. So on 15th of August 1947, two dominions came into existence. Since December 46, our Constituent Assembly was working. But after 15th of August 1947, the Constituent Assembly met again and again, most probably 86 times. Our Constituent Assembly had members from all streams. You all know that Dr. Rajendra Prasad was there. There were leaders from left, there were also few leaders from left were also there. A socialist bloc was also there. And Hindu Mahasabha, Shyama Prasad Mukherjee and several other persons, they were also there. But one thing is sure, that all were thinking to remove the social ills. And the foundation for our constitution was the objective resolution, which ultimately culminated into preamble of the Constitution of India, that we the people of India, having solemnly resolved to constitute India into sovereign, socialist and secular, these two words were subsequently added, but they were integral part of our constitution, to have a democratic republic where justice prevails, social, economic, political. Well, fraternity exists. So this was the Constitution of India, and with these values we started our national movement. You see, our fundamental rights. I am discussing what is the constitutional morality. Our Constitution, Article 14, 15, 16, they specifically talk about equality. Sometimes people say that it is equality only on part of the state. But my dear friends, it is not only and only for a state. Yes, a state is required to treat each and every person equally, but being a value of the Constitution, we all are also abide by that. A very interesting article, Article 17, that prohibits untouchability. Right to life, right of belief and faith, prohibition of all kind of beggar and immoral traffic. This is the part, third is the only part of the Constitution where the word morality is used 4 times. So our constitutional value, morality rests in our preamble, in our fundamental rights, in directive principles of the state policy, and subsequently added in 1976 in fundamental duties under Article 51A also. So whatever is stated in these parts, these are our constitutional values. These are our constitutional morals. No Indian can, while adhering his own faith, he has to respect others' religion, others' faith, others' belief. He has to give space to the liberty of other person. He has to make, he has to pave path for freedom of other people. One very interesting provision, Article 13 is there. Normally, people forget Article 13. Article 13 mentions that any law that is contrary to Part 3rd of the Constitution, means fundamental rights, shall be illegal. And it further defines the term law. And it includes that all customs and uses are also part of law. So no custom, no tradition, no usage that can go contrary to your constitutional morality. Meaning thereby, it is the constitutional morality that is supreme. And when we say that the constitutional democracy is supreme, that means the nature of your democracy the nature of your system is founded on constitutional democracy and not simple counting of heads. You must have heard about the judgment of Keshwanand Bharati. Much back in 1973, the Supreme Court held that yes, the Parliament is having authority to amend the Constitution. Parliament is certainly supreme so far as making of law is concerned, but the Supreme Court but the Parliament can't touch the basic structure of the Constitution. Basic structure is required to be kept intact. And what is basic structure? The basic structure is secularism. Basic structure is the socialism as devised in our Constitution. It is a fraternity, or to say prohibition of all those ills which are contrary to the Part 3rd of the Constitution of India. Those can't be enforced by amending the Constitution. So this is the constitutional morality. Our constitutional morality, integral part of our constitutional morality is secularism. Integral part of our constitutional morality is a caste-less society, or at least where no discrimination can be made on the ground of birth, on the ground of economic status, on the count of color, creed, etc. This is our constitutional morality. Friends, can we say that in last 75 years we have attained these constitutional moralities? Can we say that we have attained that state which was thought by our framers of our Constitution? Not at all. I tell you one incident. You see how we still think. In Sati system that was abolished long with in 18th century, 19th century, and 1860, around 1856 or 1860. But unfortunately, on 2nd of September 1987, a young girl of 21 years, roop cover, in a small Varala, in district Sikar of Rajasthan self-immolated or under compulsion, under intoxication, immolated with the dead body of her husband. A big chunk of population supported that. All over the India, opposition was there, a demand was there to bring a new act. The act was brought. That is abolition of sati and its glorification. 2nd September has gone few days back only. Please check the entire social media, especially the groups from Rajasthan and Madhya Pradesh and some parts of Gujarat. You will find Sati Mata Roop Kavar Ki Jai. You will find photographs of Sati Mata keeping head of her husband in her lap. So our mind still glorifies Sati. Please come to my city, where I stay, in Jodhpur. Every 5 kilometers you will find a temple of Sati Mata. X Sati Mata, Y Sati Mata, Sati Mata ka Than. And this is not only of one city, in every city of Rajasthan, some parts of Madhya Pradesh, some parts of Gujarat, neighboring parts of Gujarat, you will find Sati Mata temples. All right, the temples are old, but the faith of people, because of glorification, that is raising every day. There are the Sati Mata temples where 10 years earlier only 5 people in a year were coming. There was no footfall. But presently 1,000 people a day are going. While coming to Jodhpur on highway, you will find a very interesting thing. A Royal Enfield motorcycle. A Royal Enfield motorcycle just lying in a glass precincts with thousands of garlands. Everybody is coming and garlanding that motorcycle. A huge tirth has been developed there. Prasad, garlands, people are bowing their head. For what? They believe that this motorcycle is having some extraordinary spiritual powers, and that motorcycle is worshipped by crores of peoples. A big tirth is there only against that motorcycle. Our constitution says to develop a scientific way of life. It is part of our directive principles. But is this the scientific way? Every person, every political person passing through that road stops his or her convoy there and bow hand. So where is constitutional morality in our day-to-day life? And what Dr. Ambedkar in his famous speech on 26th of November 1949, on 25th of November, before adopting this constitution, on 25th of November 1949, he stated that our constitution is not only a political or a legal document, but essentially a social document. If we doesn't apply it in our day-to-day social life, it will fail. So we are failing our constitution. Because whenever you are talking about these things, they say this is our tradition, this is our custom, this is our culture. Friends, the biggest challenge is to distinguish social morality with social ills. Unfortunately, social ills are leading the social morality. What is social morality? These are the traditions, healthy traditions, customs, uses, which are adopted by the society, may by the mandate of law at some time, or may that be as a general acceptance. But now every wrong, only day before yesterday, on 12th of September 2025, the Supreme Court, while hearing a case relating to noise pollution, air pollution, on the count of firecrackers in the NCR in Delhi, an observation was made by Chief Justice of India, Justice Govind, that why this writ petition is confined only for, you must have read it in newspapers, that why it is, writ petition is confined only for Delhi. Why not for the entire country? All citizens are facing air pollution, noise pollution, all other ills because of these crackers. And check this social media of 13th of September, or to say from the night of the 12th of September. Justice Gavai and the Supreme Court have been abused as anything. Okay, firecrackers, this is part of our culture. Firecrackers, for a day if we are going for firecrackers, this is not this is not affecting air pollution. This is not causing any sound pollution. Everybody is saying that Supreme Court is interfering in our personal customs. I don't know whether this was a personal custom, it was a tradition, or sometime it started otherwise. Because to my knowledge, this barood was never a part of Indian culture, it was subsequently came, be that as it may. But the process of thinking of our Indian people, that how you can stop firecrackers which are part of, in any manner, part of our tradition or custom. They don't think that Article 21 gives a fundamental right to life. Yes, so far as balancing is concerned, here clearly a balancing comes in picture, the balancing. One thing I would like to convey, that how this noise pollution concept that came in judicial jurisdiction. You all must have heard of 1987, a very, not in 87, in early 19s, an incident occurred. A letter was received by Supreme Court by one Professor Anil Mittal, Dr. Anil Mittal, attaching a copy of a newspaper. The news was that in an unfortunate night, a girl was sitting, 13 years old girl was sitting in her house, and just close to her house, in her neighborhood, a loudspeaker was there, For a whole night, Jagrata was there. People were singing to the extent of, I can use a shout. And at that time, a Lafarian committed rape with that 13 years old girl. She cried. She alarmed. She called people to save her. But her voice, it was not possible to hear her because of the amplification of all other things in the loudspeaker, in the amplifier. The girl ultimately conveyed this thing to her parents, but at the same time committed suicide. She died on the same day, and the age of the girl was 13 years. The Supreme Court took cognizance of the matter. At the initial stage, the Supreme Court banned all loudspeakers, etc. after 10 p.m. Please, someday on internet you will find the pleadings of that case on net. What was the response by certain people? That our bhajans, we are pleasing our God. How it is within the domain of Supreme Court? This issue we will tackle at our own. How Supreme Court can direct to close it? Our certain gods are to be pleased only in midnight. This was the argument before the court. Supreme Court, in the name of balancing social morality and constitutional morality, modified the order, leaving it at the jurisdiction of district magistrate to permit up to 12 p.m. if some reason is there, and if you avail statistics, especially in northern India, on every application, the district magistrate who has further delegated his power to a very small officer, he is putting his initials, simple initials, nothing doing. In our local dialect, we call it Chidi Mardi. And now loudspeakers are very, very frequently, they are there up to 12, as a matter of fact, whole night. Can it be a social morality? Can it be a tradition? Can it be a custom? But this is the objective condition. So our social morality. In the name of social morality, dowry. There is an act, Dowry Prohibition Act. Fetus killings. You see all these things, and interestingly, you also have seen in the social media in last 3-4 days, a wife of a chief minister, she wore some clothings, and entire India is discussing that. That is immoral. How we are concerned? All social policing is going at war level. So we have to understand that what are the social moral and what are the social ills. We can't bring each and everything which are essentially the social ills within the four corners of social morals. In the I am of a strong opinion that so far as social ills are concerned, there can't be any compromise. Social ills are to be killed as a fatal virus. There can't be any compromise with social ills. But nowadays, it is very sad state of affairs, very sorry state of affairs, that from last 2 or 3 decades, the forces which are promoting social ills, they are giving the color of custom, they are giving the color of tradition, they are calling it sometimes a scientific background also. In last month, people were going with coward from different parts to Haridwar. Entire area was disturbed. Government passed an order in the caste line that you show your name on the shop. If you are not showing your name on the shop, it will be treated as a crime. It will be an offense. A writ petition was filed. You see, for everything these days people are filing writ petition because people are not coming on roads to agitate these issues. In writ petition, the state of Uttar Pradesh filed a reply. And in that reply, a complete scientific background was given that how the coward is necessary. An expert from the university, his report was there that yes, how this will help in promoting I don't know what this one, in releasing dopamine and certain other things, etc., etc., etc. So these people now are giving a scientific trying to give a scientific foundation also to absolutely non-scientific things. We have to understand that this is the point, this is the fine distinction where the social morals arrives at an end, and here the social ill starts. We have to fight with the social ills. There are certain other matters relating to these issues. It is unfortunate that at mass level, we people who are in public life, we are not agitating these causes. It is either the High Courts or the Supreme Court that is interfering in these matters in public interest litigation jurisdiction. There are certain very important judgments where the Supreme Court interfered. But at the same time, I always fear that the other view taken by Supreme Court that may cause lot of injury to the public movement. So first, all these social ills are required to be, the combat is required from the masses, not by the courts. Courts are not revolutionary. Courts are part of this system. I am a tool of this system. I remained lawyer for good 21 years. I remained judge of 17 years. But I understand that how your hands are tightened, how your windows of your brain are required to be kept closed. But in any way, we have a constitution, and I feel that in the present circumstances, in the present scenario, that is a wonderful book. We have to save that. We have to protect that. And by constitutional morality, we have to protect social morality and we have to combat social ills. So I give you what is social morality, a small incident, a small custom I tell you. In my city, there was a practice in the name of Ram Rasoda. You know, Rasoda means kitchen. Ram God. A lady was coming every morning in every house, collecting few rotis and a sabzi. And every house, and in every house and in kitchen of every house, 4 or 5 rotis and little bit sabzi. That was always there for Ram Rasoda. The lady was coming, carrying a container. We were putting all 4 rotis and sabzi in that. And that food was used for certain students coming from lower echelons. Nobody is taking care of that custom. I don't know what that fine or bad morning came when that system came to be abolished. Because we are not paying even 2 rupees for salary to that lady. So she was coming, or in entire city about 100 ladies were working. By flux of time, that system has gone. A healthy system has gone, but on every choraha, on every circle, Ganeshji is sitting, in Navratra, Devi is sitting, people are coming, garlanding with 500 rupees garland, dancing whole night, causing huge sound pollution. That is prevailing. Number of mandals are there for celebrating these things. But Ram Rasoda has gone. You may be having faith in God or not. You may be an atheist. But we have to protect healthy traditions. Healthy traditions are of entire society. Yes, maybe in the name of God. We are not protecting the healthy traditions. We are not supporting the social ills, but we are silent spectators. We have to come ahead from it. We have to combat all social ills. The courts have their own limitations, but yes, the legislature was also tried in 1956. Hindu Succession Act was there. An amendment was brought in Hindu Succession Act in 2005. The person sitting here with legal background, they must be knowing that in 2005, equal status or co-partnership rights were given to the daughters. Those were opposed as anything. We are not ready to treat our sister also equal to us. Only co-partnership rights as available to son, those were given to daughter, but we were not accepting those two. Ultimately, Supreme Court upheld the amendment, arrived at the conclusion that no discrimination can be made on the basis of gender, daughter is having all co-parcenary rights. And now you will find number of articles that this judgment has caused lot of troubles. Girls are demanding their in parents' property. And while saying this, they are also saying they have already taken money in the form of dowry. You see, dowry is prohibited. So instead of going for prohibiting dowry, abolishing dowry system, they want to get rid from co-parcenary right to daughter. Similarly, I have just, you see in Jallikattu's case, earlier Supreme Court prohibited complete Jallikattu by giving a reference of Animal Protection Act. Yes, it is balancing. I don't know what type of balancing, but it is balancing to a limited extent that has been allowed. I am not witness of that system, but whatever I read, I feel that that ritual can't be completed without atrocity or without any causing violence against the animal. I have not witnessed, but as I personally feel that it can't be treated, it can't be performed without atrocity to the animal. There are certainly good judgments by Supreme Court as in the transgenders case. The court has treated the transgenders as a third gender. But you see, unfortunate part is that the President of USA, in a very educated society, he want to withdraw third gender to transgenders in his country. And people in India, by referring Trump, they are criticizing Supreme Court decision. The verdict of the Supreme Court has been criticized that you know that Trump is saying this. Whatever Trump is saying, that is not a gospel truth. We have our society. We have our human instincts. We have our law. It is good that the government has now made a law by legally treating the transgenders as a third gender. There are certain other issues also, like homosexuality in Navtej Singh's case, in Sabrimala's case, where the women were from the age of 10 to 50 were not permitted to visit the temple. Supreme Court has taken a view in that matter, allowing each and every person to visit the temple. But what I say is that please don't leave all these things on the shoulders of judiciary. Ultimately, judiciary is also a tool of the system. We have to understand. We have to combat all social ills. We have to understand that these are the constitutional morals, these are the constitutional values that will prevail. Social values, social morals, yes, to the extent they are healthy, they are promoting the society, the social intent, instinct of human behavior, all right. But whenever they are causing some injury to public at large, to our system, we have to be very cruel. We have to fight against those things as anything. Yes, till that position comes, we can certainly avail benefit of public interest litigation jurisdiction. But that is not by a single man. Whenever public interest litigation word is there, means that must be followed by some public, not an individual. The first thing in public interest litigation is that first issue is the public awareness. A section of public that is committed to cause, that is ready to fight. So friends, while finishing my words, I just want to convey that we have a capacity to understand what are the good things in our traditions, what are the healthy things in our customs, what are the good actions which are to be protected and which are the ills. We have to diagnose the ills and we have to fight against those ills. We have to finish those ills. We have to promote our constitutional values, constitutional morals, which are most relevant at this juncture. Thank you.
ಇಷ್ಟೊತ್ತು ತುಂಬ ಸರಳವಾಗಿ ಸುಂದರವಾಗಿ ಇವತ್ತಿನ ವಿಷಯದ ಬಗ್ಗೆ ಉಪನ್ಯಾಸ ನೀಡಿರುವಂಥ ಜಸ್ಟಿಸ್ ಗೋವಿಂದ್ ಮಾಥುರ್ ಅವರಿಗೆ ನಾನು ನಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ. ಹೇಗೆ ನಮ್ಮ ಸ್ವಾತಂತ್ರ್ಯ ಹೋರಾಟ ಕೇವಲ ಬ್ರಿಟಿಷ ಆಧಿಪತ್ಯದ ವಿರುದ್ಧ ಮಾತ್ರ ಆಗಿರಲಿಲ್ಲ, ಬ್ರಿಟಿಷರ ಆಳ್ವಿಕೆ ಇಲ್ಲದಂಥ, ಅಂದರೆ ನೇರವಾದ ಆಳ್ವಿಕೆ ಇಲ್ಲದಂಥ ರಾಜಾಡಳಿತಗಳಿದ್ದಂಥ ಪ್ರದೇಶಗಳಲ್ಲಿಯೂ ಕೂಡ ಅವರು ರಾಜಸ್ಥಾನದವರು. ಸೊ ರಾಜಸ್ಥಾನ ಎಲ್ಲವೂ ಕೂಡ ಅಲ್ಲಿನ ರಜಪೂತರ ಅರಸರ ಆಡಳಿತದಲ್ಲಿದ್ದಂಥ ಭಾಗ, ನಮ್ಮ ಮೈಸೂರು ಪ್ರದೇಶ. ಸೊ ಈ ಪ್ರದೇಶಗಳಲ್ಲಿಯೂ ಕೂಡ ಸ್ವಾತಂತ್ರ್ಯಕ್ಕಾಗಿ ಹೋರಾಟಗಳು ನಡೆದವು. ಅದು ಕೇವಲ ಏನು ಬ್ರಿಟಿಷರಿಂದ ರಾಜಕೀಯ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ಪಡೆಯುವುದಷ್ಟೇ ಆಗಿರಲಿಲ್ಲ. ಆ ಕಾಲದಲ್ಲಿ ಪ್ರಚಲಿತ ಇದ್ದಂತಹ ಜಮೀನ್ದಾರಿಕೆ, ದಬ್ಬಾಳಿಕೆ, ಶೋಷಣೆ, ಆಮೇಲೆ ಅಸ್ಪೃಶ್ಯತೆ, ಈ ರೀತಿಯಾದಂಥ ಹಲವಾರು ಸಾಮಾಜಿಕ ಪಿಡುಗುಗಳಿಂದಲೂ ಕೂಡ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ಪಡೆಯುವುದಕ್ಕೆ ರಾಜಕಾರಣಿಗಳು ಮಾತ್ರ ಅಲ್ಲ, ಕ್ರಾಂತಿಕಾರಿ ಎಡಪಂಥೀಯ ಶಕ್ತಿಗಳು, ಅದೇ ರೀತಿ ಸಮಾಜ ಸುಧಾರಕರು ಎಲ್ಲರೂ ಕೂಡ ತಮ್ಮ ತಮ್ಮ ನೆಲೆಗಳಲ್ಲಿ ಎಲ್ಲ ಪಿಡುಗುಗಳ ವಿರುದ್ಧ ಹೋರಾಟವನ್ನು ಸಂಘಟಿಸಿದರು. ಮಹಾತ್ಮ ಗಾಂಧಿಯವರು ಕೂಡ ಕೇವಲ ಬ್ರಿಟಿಷರನ್ನು ದೇಶದಿಂದ ಹೊರಹಾಕಬೇಕು ಅಂತ ಹೇಳೋ ಆ ಸ್ವಾತಂತ್ರ್ಯಕ್ಕಾಗಿ ಮಾತ್ರ ಅಲ್ಲ, ಅಸ್ಪೃಶ್ಯತೆಯ ವಿರುದ್ಧ, ಆಮೇಲೆ ಇತರ ಸಾಮಾಜಿಕ ಪಿಡುಗುಗಳ ವಿರುದ್ಧ ಕೂಡ ಮಹಾತ್ಮ ಗಾಂಧಿಯವರು ಕೂಡ ಹೋರಾಟಗಳನ್ನು ಸಂಘಟಿಸಿದರು ಅಂತ ಹೇಳುವುದನ್ನು ಬಹಳ ಸುಂದರವಾಗಿ ಅವರು ಹೇಳಿದರು. ಇಂಥ ಹೋರಾಟದಿಂದ ಹುಟ್ಟಿದಂಥ ನಮ್ಮ ಸಂವಿಧಾನ ಏನಿದೆ, ಸಂವಿಧಾನ ಸಭೆಯಲ್ಲಿ ಕೇವಲ ಕಾಂಗ್ರೆಸ್ಸಿಗರು ಮಾತ್ರ ಇದ್ದದಲ್ಲ, ಭಾರತದ ಸಂವಿಧಾನ ಸಭೆಯಲ್ಲಿ ದೇಶ ವಿಭಜನೆ ಆದಮೇಲೆ ಕಾಂಗ್ರೆಸ್ನವರಿದ್ದರು, ಎಡಪಂಥೀಯರಿದ್ದರು, ಇತರ ಕ್ರಾಂತಿಕಾರಿ ರಾಜಕಾರಣಿಗಳಿದ್ದರು, ಬಲಪಂಥೀಯ ಹಿಂದೂ ಮಹಾಸಭಾದ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಮುಖರ್ಜಿ ಅವರಂಥವರು ಕೂಡ ಸೇರಿಕೊಂಡು ಎಲ್ಲರೂ, ಅಂದರೆ ಎಲ್ಲರ ಹಿತಾಸಕ್ತಿಗಳನ್ನು ಪರಿಗಣಿಸಿ ರಚಿಸಿದಂಥ ಸಂವಿಧಾನ ನಮ್ಮದು. ಸೊ ಇದನ್ನು ಪ್ರಸ್ತುತಪಡಿಸುವಾಗ ಬಾಬಾ ಸಾಹೇಬ್ ಅಂಬೇಡ್ಕರ್ ಅವರು ಇದು ಕೇವಲ ಒಂದು ರಾಜಕೀಯ ಮತ್ತು ಕಾನೂನಿನ ಒಂದು ದಾಖಲೆ ಅಷ್ಟೇ ಅಲ್ಲ, ಇದು ಒಂದು ಸಾಮಾಜಿಕ ದಾಖಲೆ ಕೂಡ ಆಗಿದೆ ಅಂತ ಹೇಳುವ ಮಾತನ್ನು ಹೇಳಿದರು ಅಂತ ಹೇಳಿ ಅವರು ಹೇಳಿದರು. ಆದ್ದರಿಂದ ಇವತ್ತು ಸಾಂವಿಧಾನಿಕ ಏನು ನೈತಿಕತೆ ಅಂತ ಏನಿದೆ, ಅದು ಎಲ್ಲರಿಗೆ ಒಳಿತನ್ನು ಮಾಡುವಂಥದ್ದು ಏನಿದೆ, ಎಲ್ಲರನ್ನ ಸಮಾನರಾಗಿ ಕಾಣುವಂಥದ್ದು, ಎಲ್ಲರಿಗೆ ಒಳಿತನ್ನು ಮಾಡುವಂಥದ್ದು, ಅದು ಸಾಂವಿಧಾನಿಕ ನೈತಿಕತೆ. ಸಾಮಾಜಿಕ ನೈತಿಕತೆ ಅಂತ ಹೇಳಿ ನಾವು ಇವತ್ತೇನು ಅನುಭವಿಸ್ತಾ ಇದ್ದೇವೆ, ಇದು ಹೆಚ್ಚಿನ ಸಂದರ್ಭಗಳಲ್ಲಿ ಆವಾಗ ಏನು ಸ್ವಾತಂತ್ರ್ಯ ಹೋರಾಟದ ಕಾಲದಿಂದಿನಿಂದ ನಾವು ಹೋರಾಡ್ತಾ ಬಂದಿದ್ದೇವೆ ಸಾಮಾಜಿಕ ಪಿಡುಗುಗಳ ವಿರುದ್ಧ, ಈ ಪಿಡುಗುಗಳನ್ನು ವೈಭವೀಕರಿಸುವಂಥದ್ದು ಅದೇ ನೈತಿಕತೆ ಅಂತ ಹೇಳುವಂಥ ಪ್ರವೃತ್ತಿಯನ್ನು ನಾವು ಇವತ್ತು ಕಾಣ್ತಾ ಇದ್ದೇವೆ. ಕಳೆದ 20-30 ವರ್ಷಗಳಲ್ಲಿ ಇದು ದಿನದಿಂದ ದಿನಕ್ಕೆ ಹೆಚ್ಚುತ್ತಾ ಇದೆ ಅಂತ ಹೇಳುವುದನ್ನು ಉದಾಹರಣೆ ಸಮೇತವಾಗಿ ಅವರು ನಮ್ಮ ಮುಂದೆ ಇವತ್ತು ಹೇಳಿದರು. ಸತಿ ಪದ್ಧತಿಯ ಉದಾಹರಣೆಯನ್ನು ಅವರು ಕೊಟ್ಟರು. 19ನೇ ಶತಮಾನದಲ್ಲಿ ಏನು ಬ್ರಿಟಿಷ್ ಆಡಳಿತ ಇದ್ದಾಗಲೇ ಕಾನೂನಿನ ಮೂಲಕ ಅದನ್ನು ತೊಡೆದು ಹಾಕಲಾಗಿತ್ತು. ಆದರೆ ಅದು ಮತ್ತೆ 21 ವರ್ಷದ ರೂಪ್ ಕನ್ವರ್ ಅವರನ್ನು ಸತಿ ಸಾಗಮನ ಮಾಡುವುದಕ್ಕೆ ತಳ್ಳುವುದರ ಮೂಲಕ ಏನು ಮತ್ತೆ ಅದನ್ನು ಇದು ಮಾಡಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಲಾಯಿತು. ಅದಾದ ನಂತರ ಸತಿ ಸಾಗಮನ ಅಷ್ಟೇ ಅಲ್ಲ, ಅದನ್ನು ವೈಭವೀಕರಿಸುವುದನ್ನು ಕೂಡ ನಿಷೇಧಿಸುವ ಕಾನೂನನ್ನು ಮಾಡಲಾದರೂ ಕೂಡ ಇವತ್ತಿಗೂ ಕೂಡ ಸೆಪ್ಟೆಂಬರ್ 2ನೇ ತಾರೀಕು ಬಂದ ತಕ್ಷಣ ಮುಖ್ಯವಾಗಿ ರಾಜಸ್ಥಾನದಲ್ಲಿ ಮತ್ತು ಮಧ್ಯಪ್ರದೇಶದಂಥ ಭಾಗಗಳಲ್ಲಿ ರೂಪ್ ಕನ್ವರ್ ಅವರ ಚಿತ್ರವನ್ನು ಹಾಕಿ ಅವರಿಗೆ ಏನು ಗೌರವವನ್ನು ಸಲ್ಲಿಸುವಂಥ ಪ್ರಚಾರವನ್ನು ಕೊಡುವಂಥ ಕೆಲಸ ನಡೀತಾ ಇದೆ. ಸತಿ ಹೋದಂತಹ ತನ್ನ ಪತಿಯ ಚಿತೆಯಲ್ಲಿ ದಹಿಸಲ್ಪಟ್ಟಂಥ ಮಹಿಳೆಯರ ಹೆಸರಿನಲ್ಲಿ ಸ್ಥಾಪಿಸಿರುವಂಥ ದೇವಸ್ಥಾನಗಳು ಮೊದಲೆಲ್ಲ ಅಲ್ಲಲ್ಲಿ ಕಿಲೋಮೀಟ್ರಿಗೆ 5ರಂತೆ ಅಥವಾ 2 ಕಿಲೋಮೀಟ್ರಿಗೆ 5ರಂತೆ ನೀವು ಕಾಣಬಹುದು ರಾಜಸ್ಥಾನದಲ್ಲಿ. ಅಲ್ಲಿ ಮೊದಲೆಲ್ಲ 5-6 ಜನ ಅಷ್ಟೇ ಭೇಟಿಯಾಗ್ತಾ ಹೋಗ್ತಾ ಇದ್ದವರು ಈಗ ಸಾವಿರಾರು ಜನ ಅದಕ್ಕೆ ಭೇಟಿಯಾಗುವಂಥ ಮಂದಿರಗಳಾಗಿ ಅವು ಬೆಳೆದಿವೆ. ಅದೇ ರೀತಿ ಇನ್ನೊಂದು ಉದಾಹರಣೆ ಕೊಟ್ಟರು. ರಾಜಸ್ಥಾನದಲ್ಲಿ ಒಂದು ಮೋಟ್ರ್ ಸೈಕಲನ್ನು ರಸ್ತೆ ಬದಿಯಲ್ಲಿಟ್ಟು ಅದಕ್ಕೆ ಹೂ ಹಾರ ಹಾಕಿ ಅದರಿಂದ ನಮಗೆ ಒಳ್ಳೆಯದಾಗ್ತದೆ ಅಂತ ಹೇಳೋ ಮೂಢನಂಬಿಕೆಗಳನ್ನು ಪೋಷಿಸುವಂಥದ್ದು. ಸೊ ಇವೆಲ್ಲವೂ ಕೂಡ ಸಂವಿಧಾನದ ಆಶಯಗಳೇನಿದೆ ಇದಕ್ಕೆ ವಿರುದ್ಧ ಆದಂಥವು. ಇವತ್ತು ಸಾಮಾಜಿಕ ನೈತಿಕತೆ ಹೆಸರಲ್ಲಿ ವೈಭವೀಕರಿಸುವಂಥ ಪ್ರಯತ್ನಗಳಾಗ್ತಾ ಇದೆ. ಅದೇ ರೀತಿ ಏನು ಶಬ್ದ ಮಾಲಿನ್ಯ ಇದೆ, ಅದು ದೀಪಾವಳಿಯ ಪಟಾಕಿಗಳಿರ್ಬೋದು ಅಥವಾ DJ ಇರ್ಬೋದು, ಸಂಗೀತದ ಶಬ್ದ ಇರ್ಬೋದು, ಇವೆಲ್ಲವುಗಳನ್ನು ಕೂಡ ಹೇಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮಧ್ಯಪ್ರವೇಶಿಸಿ 10 ಗಂಟೆ ನಂತರ ಶಬ್ದ ಮಾಲಿನ್ಯ ಇರಬಾರ್ದು, ಅದಕ್ಕೆ ಕಾರಣವನ್ನು ಕೂಡ ಅವರು ಹೇಳಿದರು. ಒಂದು ಬಾಲಕಿ ಯಾವುದೋ ಒಂದು ಈ ಥರದ ಸಭೆ ನಡೀತಾ ಇರಬೇಕಾದ್ರೆ ಆ ಶಬ್ದ ಮಾಲಿನ್ಯ ಭಾಳ ಜೋರಾಗಿದ್ದಾಗ ಅವಳನ್ನು ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಮಾಡಲಾಯಿತು. ಅವಳು ಮತ್ತೆ ತನ್ನ ಜೀವವನ್ನೇ ಕಳ್ಕೊಂಡ್ಳು. ಸೊ ಅದನ್ನು ಒಬ್ಬರು ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದಾಗ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ 10 ಗಂಟೆ ನಂತರ ಯಾವುದೇ ಗಟ್ಟಿಯಾದ ಧ್ವನಿವರ್ಧಕಗಳನ್ನು ಬಳಸಬಾರ್ದು ಅಂತ ಆದೇಶ ಮಾಡಿದಾಗ, ಈ ಸಾಮಾಜಿಕ ನೈತಿಕತೆ ಹೆಸರಲ್ಲಿ, ನಮ್ಮ ಪರಂಪರೆ ಹೆಸರಲ್ಲಿ, ನಮ್ಮ ಧಾರ್ಮಿಕ ಶ್ರದ್ಧೆ ಹೆಸರಿನಲ್ಲಿ ಅದನ್ನು ಪ್ರಶ್ನಿಸಿದಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟು ಕೂಡ ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ರಿಯಾಯಿತಿಯನ್ನು ಕೊಡಬೇಕಾಯಿತು. 10 ಗಂಟೆ ಇದ್ದದನ್ನು 12 ಗಂಟೆ ಅಂತ ಮಾಡಿ, ಒಂದೇ ಕಾನೂನು ದೇಶವ್ಯಾಪಿಯಾಗಿರುವುದರ ಬದಲಿಗೆ ಸ್ಥಳೀಯ ಅಧಿಕಾರಿಗಳ ಜವಾಬ್ದಾರಿಗೆ ಅದನ್ನು ಬಿಡಲಾಯಿತು. ಅದರ ಪರಿಣಾಮವನ್ನು ಇವತ್ತು ನೀವೆಲ್ಲ ನೋಡ್ತಾ ಇದ್ದೀರಿ. ಯಾವ ರೀತಿಯ ನಿಯಂತ್ರಣವೂ ಇಲ್ಲ. ಇಡೀ ರಾತ್ರಿ ಕೂಡ ಗದ್ದಲ ಆಗುವುದನ್ನು ನಾವು ನೋಡ್ತಾ ಇದ್ದೇವೆ. ಸೊ ಈ ರೀತಿಯಾಗಿ ಹಲವು ಉದಾಹರಣೆಗಳ ಮೂಲಕ ಅವರು ಇವತ್ತು ನಾವು ಸಾಮಾಜಿಕ ಪಿಡುಗುಗಳನ್ನು ಸಾಮಾಜಿಕ ನೈತಿಕತೆಯ ರೂಪದಲ್ಲಿ ಮತ್ತೆ ಏರಲಿಕ್ಕೆ ಪ್ರಯತ್ನಿಸ್ತಾ ಇದ್ದೇವೆ. ಕಳೆದ 20-30 ವರ್ಷಗಳಲ್ಲಿ ಇದು ಹೆಚ್ಚಾಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳೋದನ್ನು ನಮಗೆ ಹೇಳಿದರು. ಇನ್ನೊಂದು ಭಾಳ ಆಸಕ್ತಿಯ ವಿಷಯವನ್ನು ಅವ್ರು ಏನು ಹೇಳಿದರು ಅಂತಂದರೆ, ಇದರ ವಿರುದ್ಧ ಇವತ್ತು ಕೆಲವು ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿ ಅರ್ಜಿಗಳು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಬರ್ತಾ ಇವೆ. ಈ ತೀರ್ಮಾನವನ್ನೆಲ್ಲ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಿಡ್ತಾ ಇದ್ದಾರೆ. ಇದಕ್ಕೆ ಮುಖ್ಯ ಕಾರಣ ಏನು ಅಂತಂದರೆ, ಜನರು ಬೀದಿಗೆ ಇಳಿದು ಈ ರೀತಿಯ ಸಾಮಾಜಿಕ ಪಿಡುಗುಗಳ ವಿರುದ್ಧವಾಗಿ ಅಥವಾ ಇಂಥ ಅಸಂಬದ್ಧಗಳ ವಿರುದ್ಧವಾಗಿ ಹೋರಾಟ ಮಾಡೋದ್ರ ಬದಲು ನೇರವಾಗಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬರ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳೋದನ್ನು ನಾವು ಹೇಳಿದ್ವಿ. ಅಂದರೆ ಸೂಚ್ಯವಾಗಿ ನಾವು ಇದನ್ನು ವಿರೋಧಿಸುವುದರಲ್ಲಿ ನಮ್ಮ ಧ್ವನಿಯನ್ನು ಕೂಡ ನಾವು ಕಳ್ಕೊಂಡಿದ್ದೇವೆ, ಇದನ್ನು ಕೂಡ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಿಡ್ತಾ ಇದ್ದೇವೆ ಅಂತ ಹೇಳೋದನ್ನು ಅವರು ಒಂದು ರೀತಿಯ ಎಚ್ಚರಿಕೆಯಾಗಿ ನಮಗೆ ಹೇಳಿದ್ದಾರೆ. ಆದ್ದರಿಂದ ಭಾಳ ಸುಂದರವಾಗಿ ನಮ್ಮೆಲ್ಲರಿಗೂ ಮನಮುಟ್ಟುವ ರೀತಿಯಲ್ಲಿ ಜಸ್ಟಿಸ್ ಮಾಥೂರ್ ಇವತ್ತು ಉಪನ್ಯಾಸ ನೀಡಿದ್ದಾರೆ. ಮತ್ತೊಮ್ಮೆ ಅವರಿಗೆ ನಾನು ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳ್ತೇನೆ. ನಿಮ್ಮದೇನಾದರೂ ಪ್ರಶ್ನೆಗಳಿದ್ದರೆ ದಯವಿಟ್ಟು ನೀವು ಕೇಳ್ಬೋದು.
Sir, I would like your opinion about the Rama Janmabhoomi judgment of the Supreme Court.
What is your opinion about this judgment? You see, essentially that was a civil suit that was filed before a trial court and ultimately brought before the Supreme Court. It is very difficult to read that judgment. That judgment is running in 1085 pages. So I don't think anybody has read that judgment. Only certain parts have been read. In every civil suit there are certain issues which are required to be adjudicated by the court. But in writ petitions, the court on basis of the affidavits that decides the matter, so writ petitions are summary proceedings. So it is not necessary in writ jurisdiction to decide each and every issue, but in civil suit, every issue is required to be decided. This was a civil suit. In Ram Janmabhoomi's case, that was a civil suit that was ultimately brought to the High Court. And Allahabad High Court passed a judgment. Allahabad High Court was honest enough in mentioning that we are not deciding all the issues. We are just want to curtail the dispute, so we are passing this judgment with looking to the whatever material available with us. That was challenged by way of appeal before the Supreme Court, and Supreme Court main argument was it is a dispute between two parties. So court should have decided all issues. a civil suit which essentially pertains to title on a land that has to be decided by adjudicating all the issues. This was the argument, a main argument. But unfortunately, that issue has not been decided by the Supreme Court. The Supreme Court again moved, what you say, emotions, I call that, with an idea to resolve the dispute without touching the actual dispute. Thank you.
For a very profound and but simple kind of a presentation. I would entirely agree with the kind of distinctions that you made. Certain kinds of practices are social evils and that they should be condemned and opposed. But then the instance that you gave, it's a small inquiry. The instance that you gave of the motorbike, that particular practice is not, it doesn't invoke inequality or it doesn't invoke any kind of violence. But then maybe, it is a very stupid kind of a practice. But then can we, because there are so many such stupid but not very dangerous kinds of practices, what should be the constitutionalist perspective on those supposed to be superstitious but then not very dangerous kinds of practices?
You see, when we are saying that these are social evils, these are social wrongs, but they are continuously existing in our society. May at this moment that may not be causing any harm, that may not be causing injury at large. But you see, a small virus that ultimately culminates a complete disease. So I am of the view, small or large, ills are required to be removed from our social life. Yes, you can settle your priorities that first X, then Y, whatever that may be. But in my individual's life, yours individual life, you can't accept anything to that you think that is a wrong. That can't be accepted. Thank you. Yes, please.
I understood the difference between social evils and social morality. Thank you for that clarification. I have 2-3 doubts. Like one, you said, sir, we cannot change the basic structure of the constitution, referring to secular. Now we hear that we want to change the secular word and we want to make it more communal or some other word. Now, how they can make it if that is the case? First question. Second question, how can we say that we cannot change the structure at all? Is it possible? Third thing, how we can protect the rights of minorities like food or eating anything when there is so much of going on, how to protect that? And fourthly, sir, you said that now many things are taken straight to the Supreme Court, even we have lost that opportunity to publicly protest about that. Then what is the way to protect the secular word, what we should do as a public, what is the right way to convince anyone, either Supreme Court or the politicians? And also, sir, one more question about, you said that Supreme Court, Constitution is the authority, but recently we are discussing even the Supreme Court, they cannot judge many things, the politician should do that. Then what is the way, then as a public, what we have to do? What is our stand?
Yes.
Thank you, sir.
The first thing about the efforts to remove the term secular from the Constitution, it is in our preamble only. It is in our preamble that was added by the 42nd Constitutional Amendment in 1976. It is we the people of India having solemnly resolved to constitute India into a socialist, secular, democratic republic. This is subsequent to Keshwanand Bharati's judgment. So in Keshwan, at the time of Keshwanand Bharati's case, the word secular was not there in constitution. But the Supreme Court was aware of this fact that this constitution postulates a secular country, a secular society, a secular state. So when you will read that judgment, you will find that whatever mentioned in preamble in 1976, that is already there in judgment. And while narrating that what are our social values, in Supreme Court in that judgment has nowhere mentioned that this A, B, C, D are the basic structure. But the Supreme Court mentioned that our fundamental social values are a socialistic society. But the socialistic society as per our constitution, a secular society, a democratic republic. So these all are the social values which were mentioned in the Keshwanand Bharati's judgment. And Keshwanand Bharati's judgment, that is not a judge's mind. It is only interpretation is of our constitution and what our framers of our constitution were thinking while making the Indian constitution. So secularism is an integral part of our constitution and as such is a part of our basic structure. And you know, in light of the judgment of Supreme Court in Keshwanand Bharati's case, subsequently strengthened by Maneka Gandhi's case, Minerva Mill's case, and number of other cases, secularism is a base part of basic structure, and any effort to remove secularism from preamble or in our constitution, that would not be permissible in light of law. Till Indian constitution is there, nobody can remove this word. Secularism will remain there. Yes, just a minute. Huh? I want to clarify one thing. We are not a majoritarian state. It is a constitutional democracy. Merely by majority you can't change everything. You see, then you see, I tell you one thing. Here about 100 people are sitting. To whom most of the people are watching? To me. I am sitting at least 3 feet above. You are hearing me. So most of the persons are watching me. Same position is in the court. In open court, I tell you, I am deadly against this online courts. For the reason, a judge is not a God's representative. He is not a Pagambar. He is an ordinary man. He remains honest while sitting on chair for the reason that 4 lawyers are standing before him, 100 people are sitting before him, all are watching him. If these people are not there, position would be different. These people are sitting there, they are saying, judge beimani kar raha hai. He is going to be dishonest. So when whosoever may be judge there, but if the lawyers are there, if the people are there, rest assured, nobody can remove this word secular from constitution. Any effort if made, that will be failed. And may there be some people, their voice is presently appears to be loud. But ask every person, the masses, this is, India is not only a multi-class society, it is a multi-community society. Here happiness will remain only if each and every community, each and every religion, each and every faith remains happy with their all freedom. Besides that, in our constitution, as a fundamental right, certain things are there for minorities to protect secularism. So, yes, we are required to remain vigilant. We are required to check the things. That's why I am saying that yes, it is not only the courts, it is the people also who are required to be vigilant to check all these things. So, secularism is not going to be removed from constitution. What was your next question? I am hearing, yes, please.
No. Yeah. What is the stand? What we should do as a public? Now, for example, now they will have their own way of justifying why they need to have communal, whatever the opposite word, because they say that they are majority, they are right it is, and we also have countries
you see,
like
majoritarianism is a wrong. We are all Indian citizen. What? It is citizen. That is, and so far as Indian constitution is concerned, you see, right of equality is not only for Indian citizens. When you see Article 14, it mentions person. The state shall not deny equality before law to any person. So, even it is one step ahead to citizen. It is equality relating to citizen comes only with regard to employment and other benefits under Article 15. So, you strengthen your constitution. At this stage, that is the pious document we have to strengthen. We have to make the people aware that nobody should be so powerful to change our constitution, to withdraw constitutional provisions. Ultimately, it is people's will, and it is not the people's will of this era. This is of 1,000 years old. This country has faced a lot. You see, your untouchability we have faced. We have faced several other things. So ultimately, people are remain to aware to protect their values. And
but sir, whatever we do now, everything is suppressed. So my question is, what we have to do to yeah.
You
what
know,
is the
you know little bit Hindi?
Yes, sir. Yes, sir, we understand Hindi, sir. Yes, sir.
There is one couplet. That ultimately says that पैर जब इतने जलने लगते हैं तो कमर अपने आप तन जाती है. सो अगर ऐसी कोई स्टेज आती है तो people will be there to fight for their rights.
It was a very illuminating lecture. Thank you for that. I can understand what she meant. Now these days elections are won, we know how they are won. And the government we elect is accountable for every citizen. It is not for a particular group, a particular religion or particular community and all. So is government doing the right? And who is there to check the government?
Yes. In democracy, a very vital and most important role is required to be played by political groups, social groups, literacy, educational institutions, and gathering like these people. They are required to convey the people, they are required to unite the people to save our constitutional values. You see, in our system, I can't say that if government is doing this thing wrong, then this is the law available to do this thing. It is not like this. Somewhere, ultimately, your constitution is an outcome of a freedom struggle of 90 years. So, you are again passing through a period where your struggle is for nation building, and nation building is protecting the constitution is an integral part of this struggle. Your national building movement, this is perpetual movement. You see, this time, this is not only the time of crisis, it is now we are at the stage where it has become dangerous. And I apprehend efforts shall be made to topple the constitution. But for that, we should be ready to agitate the people, to protect the constitution. This is the time where all socio-political parties, groups should unite for protecting the constitution and its values. You must be aware of the incident of Chile. In Chile, a left-oriented leader, his government was toppled. He got protection from the rightist against an army dictator. So I am not saying that what is the character of rightist here in our society. But ultimately, we have to come together to save our constitution by keeping our differences, at least at this moment, in corner. I am not saying that differences have philosophical foundation. The differences have genuine reasons. But if some big threatening is there, शेर आएगा सामने तब आपको कुत्ते से डरने की जगह उसको भी साथ लेना पड़ेगा. So you have to be prepared for a struggle. Time is certainly crossed the stage of crisis. It is not the time of crisis only. Danger is on your head. You are living in southern part of this country. It doesn't appear to be so draconian as in north. Come someday in Gujarat, come someday in Uttar Pradesh, come someday in some parts of Rajasthan. You will find it is really very, the things have taken very bad shape. This is the right time to understand the scenario. क्या हो गया आपको? Yes.
So one question. The question which I intended to ask has already been answered partly by you. But I would like to ask you the other part. Our subject today is balancing constitutional and social morality in Indian
Sorry, I
context.
can't hear you. Please come little ahead.
Our subject is today balancing constitutional and social morality in Indian context. The present day Indian context is where in every day each and every democratic institution is being demolished. Struggling for survival, at least I can see. But I would like to ask a specific question. Among these institutions, the reactionary role played by judiciary for quite some time. One of my friends asked a question, Raveendra Bhumi. Till this day, Omar Khalid had gone to jail behind bars from 2022 onwards. Judicial process was a punishment for him, as Hindu says, Delhi says. So I would like to ask, what is the reaction role played by our judiciary and how it can be rectified if it goes in this manner? whether the very constitution itself is struggling for survival, what will be the fate of the constitution tomorrow, all which I apprehend. I would like to share your opinion on these matters.
It is very difficult to say anything about you own. You are asking about the conduct and character of the judiciary. What would be the position when all other constitutional institutions are either demolished or in process for demolition? I just mentioned that we have crossed the time of social crisis. We are in real danger. And judiciary is also a part of this system. In the very beginning I mentioned that don't consider judiciary as a revolutionary organ of this system. This judiciary is a tool of the system to maintain this system, but yes, in accordance with Constitution. So it is your responsibility. Your responsibility means that it is a responsibility essentially for lawyers community, students community, all intellectuals, to remind the judiciary that you are required to remain within the four corners of Constitution. I give you certain examples. Presently, when I entered in judiciary, I started practice. The judges were not having any government car. They were coming to the courts in their own car. They were not having any personal security officer. They were not having several other amenities like bijli free, pani free, akhbar free, magazine free. These were not available to judges at that time. Entire medical expenditure for entire life, not only for you but your spouse, free. As a judge, beside my pension, I am getting 65,000 rupees per month for having an usher and to bear my telephone expenditure. These were all not available to the people, at least up to 1987. I started practice in the year 1983. Up to 1987, judges were coming, 3 judges, High Court judges were coming in a car. Nobody was there to open the door. Nothing was there. You must have heard a principle of physics, induction effect. Keep a piece of iron with magnet. After some time, that iron will acquire magnetic tendencies. That too will become a magnet to a limited extent. So all these amenities, those played a vital role. This was the induction effect of bureaucracy or the executive to change the character of judges. The day, I am very secured. Security principally given with this, that you should be very independent. But essentially it is not independence. Essentially it is calling a dog, nothing more than that. Nothing more than that. But no one, not even a single person from the judiciary or from the masses or any political party, they opposed all these amenities. You have spoiled the judges. giving these all benefits. Now you see, in my young age, I was not knowing I was knowing, yes, Justice such and such is the Chief Justice of India, but I was not knowing him by face, because his name was not there in newspapers, his picture was not in newspaper. But now, for every newspaper, there is a judicial beat, a complete जर्नलिज्म, लीगल जर्नलिज्म इज देयर. आपने हमारे मुंह वो सब चीज़ें लगा दी जो कभी केवल एग्जीक्यूटिव के पास होती थी, एंड दैट इज चेंजिंग द एंटायर सिनेरियो. इफ यू वुड हैव गिवन मी दैट ऑल राइट, योर सैलरी इज 10,000, हैव 15,000, बट अरेंज एवरीथिंग एट योर सेल्फ. एवरी पेंशनर इज डूइंग दैट. एवरी other government servant is doing that. Judge, yes, he is a constitutional functionary, but so far as his other things are, now you see a tricolor is there in the car of judge. Why? Why it was introduced? There was no need, but nobody opposed it. Now the water is flowing above head. Then we are thinking about all these issues. Yes, please oppose all these things. Don't leave judges. Only yesterday, someone was asking me that these are the wrongs in this ex-judgment, just Ram Janmabhoomi judgment. Our law permits to criticize a judgment on merits. Contempt of Courts Act doesn't mean that only protects a judge from scandalizing, not from healthy criticism of the judgment. Please criticize the judgments. What prevents you? Our intellectuals, they are also so fearful. They will criticize the government, they will criticize the legislature, they will criticize the executive, but the moment judiciary is there, they will keep silence. They are afraid of Contempt of Courts Act, and Contempt of Courts Act only stops scandalizing. You please don't say that this judgment has been passed by taking, this is an outcome of illegal gratification. Don't tell that, but tell that this judgment is running contrary to law. This judgment is running contrary to facts. This judgment is causing harm to society at large. This is permissible. Law permits for that. But we don't want to speak. We want to keep silence. And nowadays in social media, people are scandalizing the courts. This is again a dangerous phenomena. Whenever a court is protecting constitution, people are scandalizing the court. Okay, he is relative to such and such, he is such and such. You are required to protect judges also, and you are required to criticize judgment also. So these are the things to be taken care. Otherwise, we are facing a very difficult time. It is for all the institutions. You criticize, if go through the judgment of Ram Janmabhoomi. If you think that judgment is not based on law, I feel that judgment deserves rereading. That judgment deserves to be reviewed. This is my personal opinion. You please also read that. Write your opinion. Go to the court. And I just mentioned you that in every civil suit, issues are required to be decided. This is not a question of emotions or what the majority wants.
From the very appointment of judges onwards, no, I am not making any opinion personally, but from the very beginning of appointment of judges, Justice J. Swarma once made a remark that there are corrupted judges in judiciary also, and even specified percentage of them. And from the very appointment of judges, everything is opaque. Whether collegium is right or not is another question. Everything is opaque. And an opaque atmosphere is a fertile ground for corruption. Corruption not in terms of money.
Yes.
The very definition of corruption itself has changed a lot.
Yes.
It can be psychophancy, it can be uncle syndrome, it can be backdoor operation, anything can be. And unless we absorb the constitutional morality which you made very clear in your speech, how these judges are competent to be appointed? How? Have you got any screening machinery? Specific question,
May I know?
being a retired Chief Justice of a larger court, an oldest court in the country, Allahabad High Court. We even now refer to the decision of Allahabad Court every day. How these persons, these social ills in courts, social ills, are getting easy entrance to our judiciary?
May I know your good name?
Yes, you are. My name is Rajivan K, an advocate by practice. Rajivan.
Rajiv.
Yes.
Mr. Rajiv, I think this is my last answer to this gathering. Now it's already 12:15. Yes, when I'm mentioning the issue about basic structure of the Constitution, fortunately, the mode of the appointment of judges is not part of the basic structure. That can very well be amended. And that can very well be amended, and an amendment was introduced in Constitution by National Judicial Appointments Commission Act. Unfortunately or fortunately, whatever that may be, that act has been set aside. You are right, in different means or in different fashions or according to different definitions of corruption, corruption was there, may be existing, maybe at small level or at larger level. So far as I am concerned, I say that yes, the judges, the mode of the appointment of judges in this country was not perfect and is also not perfect. Collegium system, from very beginning, I am against the collegium system. I have various reasons for that. But please, as an intellectual, as an advocate, suggest the best mode. In America, it is a committee of Senate that is thrashing the man. And in spite of that, a lady judge was appointed to the Supreme Court without practicing for a single day. In earlier Soviet Union, judges were appointed after a discussion in party committees. That too was not found successful. We have to think about it, because other competitive examinations, by competitive examinations, judges of subordinate courts are coming. They are also not up to the mark. So at some point, some mode is to be adopted, but most important thing is the role of bar. You see, Bar Council of India. I don't know what is the position in the state of Karnataka, State Bar Council. The bar councils are represented on basis of caste or reason, not on merits, at least in most of the states. The elections of Bar Council of India have not taken place from several years. And very interesting mode has been adopted while electing the members of Bar Council of India. A member of Bar Council of India is term is of 5 years. But from every state, 5 persons makes a syndicate and decide that yes, for 1 year I will remain there, then I will resign, for next year you will there, then 3rd person, 4th person and 5th person. So every person in one term, 5 persons are former Bar Council of India. Nobody is taking care of bar except to call themselves as a member Bar Council of India or former member of Bar Council of India. So we all have to do collectively, raise these issues before bar also. Ultimately, in every system, some wrongs are there, some goods are there, but discussion and ultimately this is the dialectics. Thesis, antithesis and synthesis. So you have to go for dialectics. Thank you.
ಈಗ ಪ್ರೊಫೆಸರ್ ಜಯರಾಜ್ ಅಮೀನ್ ಮತ್ತು ಡಾಕ್ಟರ್ ಬಾಲಸರಸ್ವತಿಯವರು ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಗೋವಿಂದ್ ಮಾಥುರ್ ಅವರಿಗೆ ನಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಒಂದು ಸ್ಮರಣಿಕೆಯನ್ನು ಕೊಡಬೇಕಾಗಿ ಕೇಳ್ಕೊಳ್ತೀನಿ.